Welcome to Let's Get to Work, Reimagining Disability Inclusive Employment Policy, brought to you by the Burton Blatt Institute at Syracuse University. And now, here's your host, Michael Morris.
Welcome to another edition of our podcast series, Let's Get to Work, Reimagining Disability Inclusive Employment Policy. Researchers at Burton Blatt Institute at Syracuse University, in collaboration with researchers at Rutgers and Harvard universities, are studying a range of federal and state policy issues as they impact the latest trends and thinking to advance employment outcomes for youth and adults with disabilities. I'm so pleased today to have as our guest Sharon Rennert. Sharon is a senior attorney advisor at the EEOC, Equal Employment Opportunity Commission. She has been there for many, many years, has played a key role in the development and drafting and dissemination of many technical assistance materials that have been offered from the EEOC, including technical assistance materials related to COVID-19. Sharon, it's a pleasure to have you with us today and appreciate you making the time.
My pleasure. Thank you very much.
I think for our listeners, which are very diverse from the disability and employer community, it might be good to start off with just some orientation to the responsibility and role of the EEOC regarding protections for job applicants and employees, and its role in really helping employers understand their role and responsibilities. It would be great if you could start there, and obviously related to the ADA as well as the Rehabilitation Act.
The Equal Employment Opportunity Commission, the EEOC, enforces the nation's equal employment laws, and that includes the Americans with Disabilities Act, the ADA. In other words, all the laws that protect people's employment rights based on having various characteristics, things like race, sex, religion, disability. And so in regards to enforcing the law, the EEOC developed the regulations that interpret and expand upon the statute that Congress passed. In addition, we take complaints of discrimination. I think later in the program, we'll talk a bit more about that. But our role is as an investigator. We're a neutral party when people file complaints under the ADA. Then it is our job to investigate and reach a determination. You mentioned the Rehabilitation Act. That is the sister law to the ADA. The ADA applies to private employers if they have a minimum of 15 employees. The ADA applies to state and local government agencies as employers, but it does not apply to the federal government as an employer. Rather, the Rehabilitation Act is the law that covers federal agencies as employers. Now, the Rehabilitation Act and the ADA are identical in their employment protections. There's no difference between them. It's one set of regulations that cover them. It's simply that we've got two different laws here, and the other big difference is in the enforcement, which we'll also, I know, discuss later in the program.
Okay, that gives us some basic understandings. Let's go to, how does the ADA define disability, and how does that definition apply to individuals with either COVID, and particularly in our case for discussion, long COVID?
we're talking about a law, and a law can be very technical at times. And this is one of those areas that I think, especially for people who have recently been diagnosed with long COVID, so their first time dealing with the ADA, or again, the sister law, the Rehabilitation Act, it can seem a little overwhelming. So let's see if I can try to make this as clear and simple as possible. There is no list of conditions under the ADA that says, here are the conditions that are disabilities. Rather, we have 3 definitions of disability. And it's always a kind of individualized determination of a specific person, their specific medical condition, whether it meets the definition. Of the 3 definitions, the one that is probably most relevant to people with long COVID is going to be the first definition, an impairment that substantially limits a major life activity. Okay, that's a mouthful. I don't want people to get nervous about that. Let's try to break it down. An impairment. It's basically, what's the medical condition? So long COVID is an impairment. COVID-19 is an impairment. But here's where there's going to start to be a distinction. It's very easy to identify an impairment. The common cold is an impairment. The common cold will never be an ADA disability. And in most instances, neither will COVID-19. COVID-19 can be unpleasant. For some people, more unpleasant than others. You can feel pretty awful in different ways for a few days, a week, maybe even as long as 2 weeks. But then it's over and done with. Nothing goes on after that. You're back to health, and you put it behind you. Here's where long COVID starts to diverge, and we get into the other parts of this definition. It's an impairment that can substantially limit a major life activity. Let's start with major life activities. What this is getting at is, in what way does this medical condition impact somebody, affect them, impede them? Major life activities include what we refer to as major bodily function. So for long COVID, how is it impacting you? If you have lost your sense of taste or smell, those are considered major bodily functions. I've lost them. I can't taste anything. I can't smell anything. If I have brain fog, that's neurological. There's another major bodily function. If I'm short of breath, your lungs, that's a major bodily function. I'm having heart palpitations or other kinds of impact. That's your cardiovascular system. All of these are, as you can see, not too hard to identify a major bodily function potentially impacted. We look at the specific person. How's it impacting this person? Not generally, but how's it impacting this person? Okay, so the third key term here, substantially limiting a major life activity or major bodily function. That sounds kind of like a high standard, substantially limit, but it really is not. And there are various factors that are considered here. Let's start with how long the condition lasts. The reason COVID-19 is generally not going to come in as a disability here is because it just doesn't last long enough. There is no set time period that something has to last, but generally in the neighborhood of several months, a few months, right? A few days, a few weeks, no, that's not going to be enough. But as long as you can show at least a few months, and again, that's what is true of long COVID by and large, then yes, you can check off that box. We also do look at the severity of the impact here. So again, it's identifying in what way for this person does long COVID manifest? And one of the things with long COVID is it can impact people in different ways. Some people have brain fog, some people do not. Some people lose a sense of taste or smell, others do not. So we're looking at the particular person, not looking up in some medical dictionary what's possible to happen, but what's happening with this person. So there are a number of factors. There are more that you can read about on EEOC's website, but EEOC has noted that long COVID can be a disability. One of the things there you're going to have access to, along with the podcast for various EEOC publications, in our COVID-19 publication, What You Should Know About COVID-19. In the section in which we discuss the definition of disability, that'll be section N. In N2, you will read about how long COVID can meet this definition of disability. So I realize that's a lot, but that's what we do with all disabilities. It's not just long COVID. This is the process that one goes through to determine for this person, is their medical condition rising to the level of a disability. But generally with long COVID, yes, you'll meet that definition.
And again, as you've explained, just because a person says they're experiencing long COVID doesn't categorically make them a person with a disability and eligible for the protections under the ADA. It's got to be looked at on a case-by-case individual basis.
Yes, it's always going to be approached that way. But again, it's not a high bar. I don't want individuals with long COVID to think, oh my goodness, I may not be able to show this. You're going to get some information. I mean, somebody diagnosed you with long COVID, so there's the medical professional. We don't want employers thinking that long COVID can't be covered. EEOC has started to file some lawsuits involving long COVID. It's one way that we start making the point about what can be a disability. And in one recent lawsuit we filed against A&A Appliance Company, this comes from almost the very beginning of the pandemic, is somebody with long COVID. If you remember, when long COVID started to appear among individuals, it wasn't called long COVID. Nobody knew what this was, but they knew that something was happening that wasn't what was expected with COVID-19. As I said earlier, a few days, couple of weeks, it was over and done with. These people were presenting with symptoms that were not present in those first couple of weeks of having COVID-19. It was going on and on. It was new. And so there wasn't a given name back then. Long haul COVID was really the first attempt to kind of name this. And so one point of this lawsuit is this was in the early days of the pandemic. And yet this was a person with long COVID, even if it wasn't quite named that at the time. They were on leave. They needed an extension of leave. The employer denied it without really discussing that. We're going to talk more about those kinds of issues, I know, in a few minutes. But I think one point of the lawsuit is to emphasize to employers in particular, but to everybody, is that it's really important for employers to slow down, think carefully about what medical information they have, even if there's not yet a definitive diagnosis. If it's pretty clear that it's meeting the ADA definition of disability, there is a medical condition, it's substantially limiting a major life activity or major bodily function, even if there's not yet a definitive diagnosis, and that took a while with long COVID, it still might be under the ADA. So again, employers need to be very thoughtful about this.
That's really very, very helpful. So let's move to the person with long COVID is qualified as a person with a disability under the ADA. What are the protections the ADA offers to either applicants or employees? Again, thinking about people with long COVID.
Mm-hmm. It's very broad. And in this way, the ADA is very similar to the other employment discrimination laws, protecting people with other characteristics. It does begin, as you mentioned, with being an applicant. An employer cannot discriminate against a qualified individual with a disability in hiring. So an employer that learns that this applicant who they have just extended a job offer to has long COVID and says, oh, we don't want somebody with long COVID. And so they revoke the job offer. That can be illegal under the ADA. If that's the only reason, is simply that this person has long COVID. They have no indication that the person is suddenly unqualified. They did offer them a job. So it's really the basis of having this disability that is illegal. So that's the first opening in terms of protections right there when you are an applicant. Also, there are protections in terms of when employers can ask whether people have disabilities. They cannot do that prior to making a job offer. So if an employer, as part of the application process, gives you a medical questionnaire to fill out, that's illegal under the ADA. They are not allowed to do that prior to making a job offer. Once you become an employee, all kinds of protections. Again, you cannot be just summarily fired or terminated because an employer learns you have a disability. That fact alone is not sufficient. There's protections in terms of the job assignments you get, in terms of eligibility for promotion. Harassment. A lot of times people think about workplace harassment in terms of sexual harassment or on the basis of, say, race. It is also against the law to harass somebody on the basis of disability. So there are other protections. So it's pretty wide ranging in terms of the protections available under the ADA. And again, remember the sister law, the Rehabilitation Act.
I'm sure in the nature of your position, you hear about a lot of work-related issues that may be brought to your attention. And you've talked about job applicants are covered, as well as employees. You may also be getting inquiries from employers. Can you share about, during this COVID period where, although the emergency status is ended, it's still with us, and COVID is very much still a set of issues, particularly with the millions of people who have long COVID. What kinds of issues have been coming in front of you?
I think that the major issue that is coming up, but particularly for individuals with long COVID, is access to reasonable accommodation. And again, this is another protection, if you will, potential protection under the ADA. And it is somewhat unique in terms of the anti-discrimination laws. Although less unique now that we also have accommodations for individuals who are pregnant. But the concept of reasonable accommodation developed under the ADA and the Rehabilitation Act was a recognition that individuals sometimes, not all the time, but sometimes with a disability can still do a job. They're qualified to do a job, but because of the disability, they may need to do it in a different way. And that's where reasonable accommodation comes into play. This can be an obligation, a legal obligation for an employer to provide reasonable accommodations to enable an individual to perform a job, or if you're an applicant, to apply for a job. Sometimes you need reasonable accommodation for that. So let's assume for a moment that the employer has certain dates to do interviews for a job, but one has long COVID and there's a flare up on that day. But know from experience, it's probably just a day or two. And so you want the employer to reschedule your interview date. Now, this employer generally doesn't reschedule. It's like, here are the days we're interviewing, and if you can't meet us on those days, then forget it. Well, in this instance, the employer can't do that. The employer does have to consider where your disability is preventing you from doing the interview on that day. They can't summarily reject that request. As an employee, you may be requiring reasonable accommodations in order to do the job. And I think we're going to be talking more about that in a moment. But the idea here is that I think most of the contacts we are getting, certainly from individuals, tend to be about the issue of reasonable accommodation, what they may be getting, about employers that are turning them down. So again, employers need to slow down here. They should be very careful when they get a request for accommodation. And remember, a request for accommodation is very simple. It's very plain English. Employer, I have this medical condition and I need you to do something for me. That's all it takes to request reasonable accommodation. And so employers need to make sure that at every level, supervisors, managers, all your HR people are familiar with this, that they'll recognize it's a request for reasonable accommodation, they'll slow down, and they won't summarily dismiss, which is what happened in this A&A appliance company case, this lawsuit I mentioned a moment ago, where it was a request to extend leave. And they just kind of summarily dismissed it, terminated somebody, and that's what you don't want to have happen. There may have been legitimate grounds to reject the request, but summarily dismissing it like that, that's what opened them to the challenge from EEOC.
And from the employer perspective, what's the level of medical documentation they could require if an employee requests what they believe is reasonable accommodation because of long COVID?
One of the things that everyone needs to understand about the ADA is that there are no hard and fast rules, because every situation is different. Disabilities are different, jobs are different. In a question about medical documentation, let's start by saying, yes, employers who receive requests for reasonable accommodation generally will be entitled to get at least some types of medical documentation to support the request. But what they're entitled to get will differ. So for example, do you really have this condition? Long COVID has to be diagnosed by somebody. And again, sometimes with long COVID, it's gotten better over time in terms of diagnosing it. A lot of medical professionals initially, we've never seen this. We don't know how to diagnose it. Still, even today, what we hear is that sometimes it's a process of elimination. People present with certain symptoms, and so a doctor, or sometimes multiple doctors, are being brought in. So it's a process of elimination. We know that this person has something. We yet don't know what exactly. We've ruled out certain things. Here's what we've ruled out. The easiest is, of course, where they actually have come to the diagnosis of long COVID. So it's not the individual who gets to say, well, I've diagnosed myself. I think I've got long COVID. That's one reason employers are entitled to medical documentation, is the confirmation that, yes, this is a person diagnosed with long COVID or whatever the condition may be. Also, medical documentation might be required to support why you're asking for certain types of accommodations. Again, the employer doesn't have to be knowledgeable or an expert in any given disability or in any given accommodation for certain disabilities. Sometimes it's pretty obvious what the disability is, like, somebody who's deaf. An employer can't, in that circumstance, say, oh, I want an audiologist to attest that you actually are deaf, if it's pretty clear the person is. It's not clear by talking to or looking at someone, generally, they have long COVID. Similarly, that the person who's deaf wants a sign language interpreter to participate in a staff meeting, you don't need medical documentation for that. But that somebody with long COVID is asking for a different work schedule as a reasonable accommodation, is asking to work from home as a reasonable accommodation, is asking to have their where they sit in the workplace altered, moved to a different location. These are not obvious things, and that may be why an employer wants medical documentation, that the medical professional can explain what is it about long COVID that necessitates any of these accommodations. Because to be entitled to an accommodation under the ADA, you have to have a disability-related need. It's not enough to say, I have a disability. You have to be able to explain and sometimes show through medical documentation there is a disability-related need for it.
You've touched on, I think, what has been a really challenging issue to many people today is employers during this COVID era really began to be more flexible in terms of letting people work from home. Again, it depends upon the job setting and the job requirements. But now what we've really seen is a shift towards really demanding that workers come back. And so I think you've partially answered this already, but if a person seeks as a reasonable accommodation with long COVID to be able to work from home, what are the balancing of interests here? How does one look at this?
Absolutely. Working from home, what we commonly might refer to as telework. Some employers may refer to it as remote work. All of those are recognized as forms of reasonable accommodation. So it's not the name, telework, working at home, remote work. It's that concept. Yes, it is a potential form of reasonable accommodation. The issue, again, is going to be the two things. One is that there is a disability-related need for it. Just like I said a moment ago, the mere fact anyone has any particular disability doesn't automatically entitle them to any accommodation they're asking for. They have to be able to explain and show why there's a disability-related need for it. So, for example, if I am easily fatigued because of long COVID, hey, the commute, it takes over an hour and that just drains me of my limited energy. I want to put that limited energy into doing my job. Therefore, working from home allows me to preserve my energy. Maybe I can do my job by sitting up in bed, if it's a kind of an office type job with a laptop, or lying on the couch. All of this is in service to me actually performing my job. Now, of course, you do have to be performing your job, but that can be a reason related to the disability to need to telework, whether it's part-time or full-time. That needs to be discussed with the employer. In terms of what else is very relevant, it's not just the disability-related need. We see lots of cases where it's pretty clear the disability might necessitate telework. But the other very critical issue is, can you perform your job duties if you're not in the workplace? To take a kind of obvious and silly example, if your job is about restocking grocery store shelves, Well, clearly you can't do that by working from home. So that is often an issue in terms of people requesting telework. And in terms of the ADA and the Rehabilitation Act, the focus of this discussion is on what the law calls the essential functions. Again, it's a legal term, but what it really means is for this person in their particular position, what are their fundamental job duties, their primary job duties? And the law contrasts essential functions with marginal functions, as the name implies. These are not the central fundamental job duties, they're more incidental. A person with a disability, even with reasonable accommodation, has to be able to perform all their essential functions. So when talking between the employee and the employer about potential accommodations, including telework, that's going to be part of the discussion. Will that enable the individual to perform all their essential functions? Sometimes when I'm working with either employees or employers around telework, sometimes it's about a particular essential function can only be performed in the workplace. So full-time telework is out of the question, can't be done remotely. So then it's about how long does it take to perform an essential function that has to be done in the workplace. It's about, does it have to be done on a certain day, or is there flexibility there? Does it have to be done at a certain point in a day, or is there flexibility on the timing of this? Notice how it gets into the weeds here. And one of the things with any type of accommodation request, how important this discussion is between an employer and an employee. It's called the interactive process. I like to say it's about the employer and the person talking to each other. That's what the interactive process is meant, is that the people are talking to each other. The employer needs to learn all of this. The individual needs to articulate all of this. The employer needs to express their concerns. How's the job going to really be performed? And to get into the weeds, get into particular job duties. And so this kind of discussion back and forth is such a critical part of any request for reasonable accommodation, but certainly around telework. And the last thing I want to say about telework, because it's so critical to say it, is that a lot of employers, as you mentioned, brought people back to the workplace. What you do with employees generally in terms of either requiring full-time in the workplace or hybrid schedules, that's up to the employer. But a form of reasonable accommodation is to make an exception to your workplace policies. Rules around telework are workplace policies. If a particular employee as a reasonable accommodation needs, to some extent, telework as reasonable accommodation, the employer can't simply say, oh, that's against our workplace policy. We don't offer telework anymore. That can be a violation of the ADA. That's why an employer needs to, again, slow down, talk about this, focus on the disability-related need, focus on performing the essential functions with telework. But one thing that EEOC does not recognize, that a lot of employers are bringing up why they don't want to offer telework as an accommodation, is around arguments, for example, that, well, this job requires working, having teamwork. And you can't be part of a team or develop that affinity for your fellow coworkers if you're working remotely. Or what we've heard from some employers is, we value camaraderie, and you can't foster employee camaraderie if everyone's not in the workplace. Our culture at this company is about everybody being in the workplace. I think you get the idea. Notice how general these concepts are: camaraderie, teamwork. the culture of our company. What does that mean? And this is the question that EEOC will be asking employers if we're investigating a complaint of denial of telework, and we have been. And these are arguments employers are putting forth. And so this is really something directed to employers is please understand that these kinds of statements are not necessarily indicative of essential functions or that somebody can't do the job. They do their essential functions remotely. You can have camaraderie and teamwork even if people are working remotely. I do a lot of training around this. It means you're doing it in a different way. Yes, you're not present in the workplace, but I really want to urge employers to think thoughtfully about this because this is coming up time and time again. And it's very concerning to EEOC because we don't believe it is appropriate or sufficient rationales to be denying telework as an accommodation.
It's a complicated topic because of the many competing interests and claims. I wonder if you can factor yet another key part of ADA has to do with a defense for an employer is the possibility of undue hardship. And what does that mean? And how would that play in the circumstances? Again, trying to think of some examples of people trying to deal with long COVID.
Certainly, the law requires employers to provide reasonable accommodation, but not if it will cause a particular accommodation will cause an undue hardship. Undue hardship means significant expense or significant difficulty. Over the decades, what we've learned is rarely does a form of accommodation cost too much money. What does it mean to be significantly expensive? Again, you can tell by the use of the term significant. It's not like there's a dollar amount here. It is about looking at what does an accommodation cost versus the total resources, financial resources available to the entire entity. So not just a particular division or office, we put it up against the entire entity. And that's one of the reasons it's very hard for an employer to show that there's a significant expense. Also, most accommodations that cost money just don't cost that much. Some things do, I won't pretend otherwise, but most do not. So if there's an undue hardship argument, often it's the significant difficulty, and that's going to depend on the circumstances. One thing can be that you're not able to produce work by required deadlines. Okay, we can't fudge certain deadlines here. There are things that have to be done at certain times, and if a reasonable accommodation isn't going to permit that, that can be evidence of undue hardship. If it's about, making coworkers step in more than they can't get their own work done, that can be evidence of significant difficulty. So there are many different ways that it can come up. But again, it's so important for the employer and the individual to be discussing all of this. Sometimes it's not clear cut that there really is an undue hardship, but an employer may have doubts. And one of the techniques I like when it gets to that point is a trial period. Trying out an accommodation. Employer doesn't really have enough evidence to say, yep, there's an undue hardship, or yes, you won't be able to perform an essential function, but they do have some concerns. And this is where a trial period can be so helpful. There's not a whole lot to risk. This is not in the law. It's a technique that I can't take full credit. I think any number of us came up with the idea, but employers and individuals with disability over the years have said it's been very helpful, and often very helpful for employers because it was a chance in real time to test something out, maybe for 2, 3, 4 weeks. I mean, not for months on end, but a few weeks, give it a chance. But to see, is there going to be a problem? If a problem truly develops, well, in good faith, everybody tried it, and now you actually do have some evidence it doesn't work. On the other hand, what we often get feedback on is it does work. And so a trial period can be a wonderful tool where it isn't, definitive that it won't work, but employers a little nervous. Sometimes it's the individual. Sometimes the employer has the idea and the individual isn't sure. So it can work that way too. But I'm a big proponent of a trial period. Test it out.
That's a great concept. It is in terms of, as you described, that interactive process. Why not? Why why kind of not be more flexible and think through? I guess it would be helpful if individuals with disabilities who for the first time are thinking about long COVID as a disability and understanding how can the EEOC help them. Obviously, you have a lot of resources and materials, but if they really feel that their rights are being violated, what's the process? How does one file a charge? Is that the first step? Or are there other things that they can do in terms of talking with the EEOC before moving to that step?
In terms of filing, as you said, the charge, think of it as a complaint of discrimination. But we call them charges. That's what you will see if you go to the EEOC website or start this process. First of all, this will be the process for those who believe they have been discriminated against by a private employer. And again, remember, the employer has to have a minimum of 15 employees to be covered here, or a state and local government agency as an employer. We don't care how many employees. You can have 2 employees, but if you're a state or local government agency, you're also covered by the ADA. So then you're coming to the EEOC. I'm going to talk about applicants for federal jobs or federal employees in a moment. You have a different process. But people covered under the ADA, you would come to EEOC, specifically our website. That's where this all begins, eeoc.gov. And you'd be clicking on our homepage to get to filing a charge. And we have lots of information. We explain the whole process to you. What I always want people to understand, it is a long process. People come to us with the idea that, hey, in a few weeks, a couple of months, EEOC, you will have, investigated and you'll have a solution, a resolution for us. I'm afraid that is just not possible. It is going to be a very long, as in many, many months. I tell people, picture yourself getting at the back of a very long, slow-moving line. Unfortunately, that's the reality. I wish I could tell you differently. So it begins by going to our website. You're going to be walked through, the process. You can have a third party help you with that. Sometimes with something like long COVID, people are tired or easily exhausted, or the brain fog. That's one of the ways it manifests. So it may be a little overwhelming. So it's fine to have a third party assist you. If you really need some help from EEOC, then you'll find out how to contact us and we will help you with this. It should not be a barrier. We don't want barriers here, but generally you're going to put in your information. Eventually an interview will be scheduled with an investigator so they can hear what your story is. They can give you some feedback. Sometimes it's things that we can immediately say, that's just not covered under the law. So we can give you some feedback. Then they'll draft up a charge of discrimination. You will sign it. Now it's official. And now we would go reach out to the employer because they have to be notified and we have to investigate. We're not representing anybody here. We are neutral. And so we'll get the story and the information from the individual filing the charge. We get the employer's side of it. There can be many parts to this step, all leading to us making a decision. But again, I have to emphasize, it is a very long process. If you are an applicant to a federal agency or you work for a federal agency, you're going to do something different. You are going to file your complaint with the federal agency, not with EEOC. And again, we explain this on our website. We have a page for federal applicants, federal employees, but it starts with the agency in question. You go to them. They will do the investigation. EEOC's role when it comes to federal employment, we are an appellate review board, basically. If you're not happy with the decision of the federal agency, you can choose to appeal it to EEOC, but we do not do the initial investigations. It's important either, you're filing with EEOC or you're filing with the federal agencies. There are deadlines and you need to be aware of them and pay attention. For federal agencies, it's pretty short. It's 45 days from the date of the alleged discriminatory action. You have only 45 days to file. So what I tell people is, don't hesitate, get in there and file. You can always withdraw it. All right. If you jump the gun or something, you can withdraw it, but you better file it. You don't want to lose. For those in the private sector, state and local governments, you have longer timelines. You have at least 180 days. In some states, as much as 100 days. Again, the website will tell you which you have. But again, because it's a lengthy process, as I said, as soon as you think that you've been discriminated against, get in that long line. You can always get out of it later, okay? You have total control here. It's not that, we're going to force you to go through with it, but I'd rather you start the process. But you keep an eye on, the 180 days or the 300 days. I don't want people, getting into this, when you're at day 175 and it's 180 days, or day 300, 290 as the 300-day clock is about to end.
Although there are deadlines for filing, the actual investigation or taking up of your complaint, either at the federal level or with private employers, state or local government, there are no timelines. I mean, you're in a queue, but
yeah, they certainly, in terms of state, local governments, private entities, there isn't. And these can, the length of time depends on a lot of different factors. It really is next to impossible to say how long an investigation will take. And some of it, frankly, is resources. We just don't have enough investigators to get to things as quickly as we'd like to as well. One of the ways that people can certainly help themselves, whether it's with federal agencies or with EEOC, is to take time, make the initial contact, but then, as you hear, you're not going to be interviewed immediately, to kind of write down what happened or organize your thoughts. And I'm not suggesting here you have to write voluminous notes or something, but it is very helpful for you to kind of organize what happened, who did you talk to, what did they say, what did you say. If there were documents presented, you get that in order. I realize this is very emotional for people, but to the extent that you can keep your emotions out of it, it's to your benefit. You really want to listen to what an investigator is asking you. You really need to respond to that. I said, these are emotional issues for the people who are filing. We understand that, but sometimes that emotion gets in the way, and it can actually slow down the process because people want to tell their emotional story and not always answer the questions we need them to answer. So hopefully that helps.
Okay. We're just about out of time. As you've mentioned several times, there are a lot of resources available on the EEOC website. Perhaps we're going to link when the podcast is released those resources. Anything further you want to mention about that?
Well, as you said, we are going to have some of the most relevant publications will accompany the podcast and can be worth people's time to take a look at. One of the things I want people to understand with long COVID is a lot of the most relevant publications won't even mention long COVID because so many of our publications are really just about disabilities in general. And that's important. So, for example, one of the publications that I want people to look at is we have what we call an enforcement guidance on reasonable accommodation. The law doesn't change because of the disability. It's still the same law governing reasonable accommodation as a right to individuals with disabilities, as an obligation of employers. So if you're kind of going through it and going, oh, but I don't even see long COVID mentioned, that publication was last updated in 2008, I think it was. Well, that was before long COVID, anybody had ever heard of it. So don't panic that you don't see a reference to long COVID. You're going to be covered by those same rules that you're reading in that guidance on reasonable accommodation. You will have the reference to our COVID-19 publication. We do mention long COVID in various places. So you will have that, but most of our EEOC publications won't. And let me put a plug in here for an organization that isn't part of EEOC, but it is really relevant to a lot of what we've discussed today, and that is the Job Accommodation Network. If you're not familiar with them, and again, whether you're an employer or an individual with a disability, they're terrific. We work with them all the time. They are federally funded, but as the name implies, what they do is come up with ideas about reasonable accommodations for every kind of disability you can imagine, including long COVID. They have pages now devoted to long COVID. So you get a lot of information on the website, but the other thing is they offer counselors who you can talk to. And I love their counselors. They are trained in certain disabilities. They don't handle accommodations across the board. They're trained. So if you're going to talk to somebody, a counselor on long COVID, this person has really been trained about long COVID and accommodations that are particular to them. People who first develop a disability often have no idea what is meant by an accommodation, what might be useful. That's where the Job Accommodation Network can really help. It can familiarize you. You might see like, oh, that's my situation. That's an accommodation that might help me. It's a great way to kind of educate yourself as a person with a new disability as to what accommodations are there, but as well for employers. It is also very helpful to them. So I give quite a plug for the Job Accommodation Network.
Excellent suggestion and recommendation. Sharon, you have provided so much useful information and advice, not just for individuals with long COVID, but also for employers and how they interact with their employees or even job applicants. So I want to thank you for giving us the time today. And I believe this information is going to be so helpful to our audience in the months to come. Thank you so much.
Well, again, thank you for this opportunity. Really appreciate it.
You've been listening to Let's Get to Work, Reimagining Disability Inclusive Employment Policy, brought to you by the Burton Blatt Institute at Syracuse University. Don't forget to subscribe to the podcast at Apple Podcasts, Google Podcasts, or wherever you listen to podcasts.